Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. The Supreme Court, after the winter break and at the start of the new year 2023, has delivered a key judgment in 56 petition challenging the centre's November 26 notification demonetizing ₹500 and ₹1000 currency notes. A 5-judge constitution bench with a majority of 4-1 has upheld the decision. While Justice B.R. Gavai, who authored the majority view on behalf of himself, Justice S. Abdul Nazir, Justice A.S. Bopanna and Justice V. Subramanian upheld the decision as bereft of any unconstitutionality, Justice B.D. Nagarathna has written a dissenting opinion, declaring it as vitiated and unlawful. However, she agreed that the status quo ante cannot be restored now. The majority view was that demonetization cannot be struck down on the grounds of proportionality. The three purposes set out in the policy are proper purposes and they are reasonable nexus between the objects and the means to achieve them, and that it's not relevant whether the objectives are actually achieved or not, the court ruled. The court also ruled that the period prescribed of 52 days cannot said to be unreasonable, taking in note the previous exercise of demonetization. Justice Nagarathna, in her dissenting opinion, has observed that demonetization ought to have been done through a legislation and not through a gazetted notification. Parliament is a miniature of the country and the centre of the democracy and therefore cannot be left aloof in such critical matter, she said, while adding that there was no independent application of mind by the Reserve Bank of India and that the entire exercise was carried out rather in a hurry within 24 hours. There were 6 questions of law framed surrounding relationship of Centre and Reserve Bank of India, RBI Act provisos and decision-making process, doctrine of proportionality, etc. Another constitution bench has majorly ruled that additional restrictions on free speech of public representatives cannot be imposed and that their freedoms cannot be curtailed in a democracy. MPs, MLAs enjoy freedom of speech in equal measure as any other citizens under Article 19(1)(a) of the Constitution of India, the court observed. Noting that statements made by a minister related to the government or its affairs cannot be vicariously attributed to the government, the court asserted that the restrictions on the freedom of speech of public functionaries cannot go beyond what is prescribed under Article 19(2) of the Constitution, which are exhaustive and applicable to all the citizens. The Supreme Court has notably ruled that cinema hall owners have discretion to ban people from taking outside food but at the same time are obliged to provide hygienic drinking water free of cost. A division bench of Chief Justice D.Y. Chandrachud and Justice P.S. Narasimha, while adjudicating on a petition that called for a ban on food from outside at cinema halls and multiplexes, asserted that they have the right to set terms and conditions and decided whether to allow food beverages from outside or not. The court, however, made an exception for infants and stated that carrying reasonable amount of food for them should be permissible. It was contended that the cinema tickets represents a contract between a movie goer and the theatre, and in the absence of prohibition printed on the ticket, outside food could not be prohibited. The Supreme Court has advised magistrates to must remain cautious while examining the facts to ascertain as to whether a certain case actually constitutes a criminal wrong or a civil dispute merely given criminal colour. The division bench of Justice Sanjeev Khanna and Justice J.K. Maheshwari observed that summoning orders should not be passed lightly or as a matter of course, and when the violation of law alleged is clearly debatable and doubtful, either on account of paucity and lack of clarity of facts or on application of law or to the facts, the magistrate must ensure clarification of the ambiguities. It mentioned that in number of cases, the court has noted that attempts have been made by the parties to invoke jurisdiction of criminal courts by filing vicious criminal complaints by camouflaging allegations which were ex facie outrageous or pure civil claim. These attempts are not to be entertained and should be dismissed at the threshold, the court stressed. Another division judge bench of Justice M.R. Shah and Justice C.T. Ravi Kumar of the Supreme Court has held that while considering actual imprisonment, the period of parole is to be excluded. The court observed that if period of parole is to be included while considering actual imprisonment, in that case, any prisoner who may be influential or may got the parole several times as there is no restriction and it can be granted several times, this may defeat the very purpose of the actual imprisonment, the court opined. Next we have Delhi High Court. The Delhi High Court, while rejecting petition filed for grant of pre-arrest bail in an FIR under Section 380 Indian Penal Code, held that only because a complaint of the wife about Sridhan is still pending does not mean that the husband can be allowed to surreptitiously throw the wife out of the matrimonial house and take away the articles. A single judge bench of the Delhi High Court, consisting of Justice Amit Bansal, reiterated that principle of audi alteram partem must be followed by the Patent Office while rejecting a patent application. The court thus set aside the impugn order and remanded back the matter to the IPO for a fresh consideration, which would consider the objection of lack of inventive step in the light of the prior art referred. Another single-judge bench of Justice Amit Mahajan has reiterated that the simple fact that multiple criminal charges are still pending against the accused cannot be used as a reason to deny bail on its own. The bench noted that the petitioner, who has been charged under Arms Act, was involved in 23 cases but was discharged, acquitted or granted bail and therefore granted him regular bail. The division judge bench of the Delhi High Court has reiterated that a private license is considered non-heritable and personal to the person to whom it is granted. It thus observed that the legal heirs of the deceased person in whose favour the license deed was executed has no right to claim it. Clause 8 of the license deed prohibited the license from subletting, assigning or otherwise parting with possession of the inhabited area or elsewhere in the graveyard of the court said. Another division judge bench held that courts through their interpretive process cannot rewrite and create a new contract between the parties. The bench held that the arbitral tribunal interpreted the terms of the contract and it is well settled that the views of arbitral tribunal cannot be interfered with except on grounds as set out in Section 34 of the Arbitration and Conciliation Act. It was held that any interference in the terms of the contract or giving a different meaning thereto than the intent which was understood by the contracting parties at the time of entering into the contract is not permissible. Now let's have an overview of other high courts. The Punjab and Haryana High Court has observed that when the family pension share of the child born out of the first marriage ceases after attaining a particular age, such share would be given to the second wife of the only surviving widow. The court clarified that the family pension scheme, being social welfare legislation, cannot, by any stretch of the imagination, be interpreted to mean that when this share of the child born out of the first marriage ceases after attaining a particular age, such share would then go into the account of the state defendant department instead of the entire share going to the second wife, that is the only surviving widow. The Chhattisgarh High Court, while rejecting an appeal under Motor Vehicle Act, wherein the appellant's contention that the respondent's account leads to the several suspicious since the FIR was lodged at a much belated stage from the date of accident, observed that preponderance of probability has to be applied while the claim application is under Motor Vehicle Act and the standard proof of required is not the same standard of proof which is required for proving a criminal case. Only because the statement of eyewitness was recorded at a belated stage or eyewitness having not disclosed this fact to any other person till the statement was recorded before police authorities cannot be a ground to disbelieve his version. The Madras High Court, while dismissing a petition seeking reservation for women in the designation of senior advocate, held that designating an advocate as a senior advocate is a matter of honour and privilege conferred upon a member of the bar. Such privilege and honour cannot be based on reservation. It must be purely based on the merit, ability and successful career of the member of the bar, irrespective of the gender, the court remarked. Section 16(2) of the Advocates Act clearly emphasizes that it is a distinction conferred and something that comes about automatically upon achieving non or predetermined standards. It is a privilege based upon the opinion of the courts considering ability, standing at the bar or special knowledge or experience in law and a subjective decision though based on objective considerations. The Bombay High Court held that the owner of the vehicle would be jointly and severally liable for the maintenance of animals under the Prevention of Cruelty to Animals Act. It is further held that merely on the ground that he is only the owner of the vehicle in which the animals were transported illegally cannot be ground to absolve him of the liability. The Jammu and Kashmir and Ladakh High Court has noted that except of the ground mentioned in Section 6(2) of the Passports Act 1967, requests for passport cannot be denied on any other ground. It was expounded that police verification report cannot override statutory provisions of Section 6 of the Passports Act. The passport officer cannot shut his eyes and act on the report without application of mind, the court said. Disposing of an FIR lodged by concealing the fact that an application under Section 156(3) Criminal Procedure Code has already been rejected, the Uttarakhand High Court stated that such proceedings cannot be allowed to continue. The court further stated that abuse of process of law, and by doing so, the informant made the order of the magistrate redundant by deceitful means. The Allahabad High Court, while interpreting provisions of Section 3 of the Muslim Women Protection of Rights on Divorce Act 1986, placing reliance on Daniel Latif versus Union of India, has observed that a Muslim divorced lady is entitled to maintenance even after the period of iddat. The court set aside the order passed by the family court, which had granted maintenance to the wife only till the period of iddat. Moving on to miscellaneous news. In another step towards digitalization of the judiciary, the Supreme Court has launched a project which will provide free access to the officials' law report of its verdict to law students, lawyers, and the general public. The Electronic Supreme Court Report (ESCR) project, unveiled by the Chief Justice of India, is an initiative to provide the digital version of the Supreme Court's judgment in the manner as they are reported in the official law report, Supreme Court Reports. These verdicts will be available on the Apex Court's website, its mobile application, and the judgment portal of the National Judicial Data Grid. Remarking that all conversion cannot be said to be illegal, the Supreme Court has agreed to hear Madhya Pradesh government's petition challenging the High Court order restraining it from prosecuting interfaith couples who get married without informing the district magistrate under the state's Freedom of Religion Act. Amid ongoing protest in Uttarakhand's Haldwani town over High Court's order allowing encroachment by the Indian Railways, the Supreme Court has for now secured the people by staying it while observing that thousands cannot be uprooted overnight. Chandigarh's District Consumer Dispute Redressal Commission has fined the famous retail chain store 24/7 Rs 25,000 for charging customer Rs 10 to 20 for carry bags upon purchase of grocery items. The Commission also directed the company to compensate the complainant for harassment and mental agony and further directed reimbursement of legal costs. Relying on State Commission's ruling in Bazaar case, it was observed that case of deficiency in service as well as unfair trade practice on part of the store stands proved. After facing a setback and NCLAT which refused to stay a CCI order on abuse of dominant position in multiple markets in the Android mobile device ecosystem case, Google is mulling approaching the Supreme Court. The top court has transferred to itself all petitions from various high courts on issue of legal recognition of same-sex marriage under the Special Marriage Act. It has sought centre's response on the same by mid-February. In the end, we have international news. Justice Norma Lucia Pena has been sworn in as the first female Chief Justice of Mexico Supreme Court. India is expected to have its first female Chief Justice by 2027. Spain has passed a transgender bill allowing anyone aged 16 or over to change gender on their ID card. However, the bill has divided Spain's female lobby, with critics warning it could erode women's rights. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.